President, ICC International Court of Arbitration, Paris, Mr. James P. Duffy, Partner, Reed Smith, New York, Mr. Amar Gupta, Partner, J. Sagar Associates, India, Mr. Vivek Mittal, Global General Counsel, Dr. Reddy's Laboratories, Mr. Murli Neelakantan, Principal Lawyer Amicus and ex Global General Counsel, Supply and Climate. Members of the ICC India Arbitration Group, ladies and gentlemen, a very good evening to all of you and good morning to those who are in the US and other parts of the world where there's still a sun shining bright. It's my great pleasure to welcome you all today at the ICC India webinar, Arbitrating Cross-Border Life Sciences Dispute. Thank you for joining us. These discussions are very important to us as we firmly believe that sharing of knowledge at such events is essential not only for ICC arbitration in India, but also for India's evolution as a pro-arbitration jurisdiction. At the outset, a few words about ICC India. We are one of the most active chapters of the Paris-based International Chamber of Commerce, which represent business organizations from more than 100 countries across the globe. ICC is a non-governmental organization and enjoys special status with institutions like the UN and specialized agencies, the WTO, G20, etc. Our three main areas of work are rule setting, dispute resolution, and policy advocacy. This also includes essential business services such as arbitration, managed by ICC's International Court of Arbitration, the world's leading arbitral institution. With the growth in international trade and investments, commercial transactions are increasingly becoming cross-border, raising serious issues about resolution of disputes. The issues are not only limited to the resolution process, but also concerns enforceability. Today, multi-party contracts are common, thus making the jurisdiction issue very complex. Turning to local courts, especially in the wake of the pandemic, is not a very business-friendly option anymore. Confidentiality, neutrality, impartiality, time and cost factors are some of the most common and lucrative offerings of arbitration. I'm happy to say that ICC arbitration rules have stood the test of time. More recently, in response to disruption caused by COVID-19, ICC issued guidelines for holding virtual hearings. Keeping a client mindset to the challenges, the 2021 ICC arbitration rules have paved the way for more efficient and transparent conduct of arbitrations with increased tools, procedures, and technology at the tribunals and parties' disposal. You will hear more on this during the course of today's discussion. Now, continuing with the event, I'm also excited to share that for today's discussion, we got over 350 registrations from places across the globe, such as the US, the UK, France, Australia, Bangladesh, Japan, Singapore, and Sri Lanka. Thank you for joining. All of you are welcome, and we're delighted to have you. Post this inaugural welcome, we will have two speakers in the inaugural session, Dr. MURTAZA KHORAKIWALA and Ms. CLAUDIA SALOMON. This will be followed by a brief thematic presentation by Mr. James Duffy. Following that, we will have a panel discussion and a Q&A session to end with. Before I conclude, I wish to thank the ICC Court President, Ms. CLAUDIA SALOMON, and her team for their support. Our webinar partners, J. Sagar and Associates, and Reed Smith for supporting today's discussion. And last but not the least, our members who have also always stood by us. In fact, I'm pleased to share that with the support of some of our members present today, we will also be hosting several of such events. And I also wish to thank my colleague and friend who I can see here today, Abhinav, for having contributed for the development of the ICC court in the Indian market. Thanks, Abhinav. Now I would request Dr. KHORAKIWALA, President ICC India, to deliver his inaugural address. Thank you.
Thank you, Imran. Distinguished guests, ladies and gentlemen, a very good evening to all of you. It is indeed a pleasure for me to address, even though virtually, this distinguished gathering present today at the ICC webinar of Arbitrating Cross-Border Life Science Disputes. While I'm often speaking of my experience as an industry person, I find myself donning many hats. And with the ICC today, I will speak in the capacity as the President of ICC India. Foremost, I would like to take this opportunity to thank the ICC Court for supporting ICC India in organizing this webinar on such a contemporary topic. It's been over a year since the country stood still with the COVID-19 pandemic. A lot has changed since then, and a lot is yet to change. Our lives have been deeply impacted by the severity of the crisis. The life science industry as a whole has responded very well to the crisis. India, not wasting a good crisis, has emerged as one of the fastest growing life science industries in the world. And there is an opportunity for India to play the role, not only as the pharmacy of the world, but also as an innovator and as a developer of solutions in the emerging crisis. Importance of this industry to India's growth and economic development cannot be overstated. India's pharmaceutical sector alone contributes about 1.7% to its GDP. India exports about 40% of the pharmaceuticals it manufactures and also supplies about 20% of the global generics market. In US alone, 1 out of every 4 medicines that are consumed by US is manufactured in India. Further, the sector is expected to grow from 42 billion currently to about $130 billion by 2030. And it is one of the very high-performing knowledge-based segments in the manufacturing sector in India today. With the expansion of the pharmaceutical industry, the established and emerging markets are seeking out new growths globally. However, this positive shift in the industry is also reciprocal to the growth in challenges and disputes concerning the industry. Challenges like changing marketplace dynamics, dilution of core drivers of success, gaps in competitive ability, and so on. These developments need attention from our policymakers at the earliest. Recently, several policy decisions have been made to boost the life science industry. The amendment of the existing FDI to allow FDI to invest up to 100% under the automatic rule for medical devices, subject to certain conditions, reflect a positive approach. While COVID itself is the root cause of so many disputes today, companies are majorly facing global contractual, non-contractual disputes. Disputes concerning licensing and manufacturing collaboration agreement, technology transfer, royalty payments, exclusivity of distribution, breach of treaty, commitments, earn-out, and non-compete issues. Indemnity and purchase price adjustments, exit disputes, and the list goes on. It is important to understand how such challenges can be resolved through arbitration. ICC is and can be a great facilitator in this process. The ease of doing business in India is a major concern, and the arbitration ecosystem is vital for its sustenance. ICC enables the parties to resolve the disputes amicably. The parties get an opportunity to resolve the disputes while preserving their relationships in the market. Today, we have distinguished speakers with us to discuss in detail and more. At ICC India, we sincerely feel that such discussions will greatly assist all the stakeholders in providing useful and nuanced insights, both at regional and global level. On this note, I would like to end and welcome all of you again to a great webinar and have a very fruitful and learning discussion. Thank you and all the best.
Thank you. Thank you very much, President. Now I would request CLAUDIA to kindly deliver her keynote address. CLAUDIA, floor is yours. Thank you.
Well, thank you so much. I am just so grateful to have the opportunity to join you today, and you can be assured that as soon as I am permitted, I will be on a plane to meet you in person in India. First, let me thank ICC India and Imran Khan for hosting this event, Reed Smith and JSA for sponsoring the program. It is a particular honor to be on the program with Dr. KHORAKIWALA, the president of ICC India, and really welcome and his very important opening remarks today. I am so pleased to be serving on the ICC court with the 2 court members from India, Kunal Vahani and Pallavi Shroff, and to have Sanjeev Kapoor serving as one of the vice presidents, an essential member of the bureau, and truly one of my trusted advisors. Today, we say goodbye, unfortunately, to Abhinav Bustan, who has been with the ICC for more than 10 years and was the regional director for South Asia. We express our heartfelt thanks for his tireless efforts. He has put ICC on the map and set the groundwork for us to continue to build. And with us today, though, is Abhinav's successor, our new regional director for South Asia, Tejas Chauhan. Tejas is a lawyer based out of India who worked previously with ICC India for several years. He assisted the court on its activities and promotion in India and worked directly with Abhinav. And most recently, he's worked at PwC in India as a manager with their forensic and dispute advisory services. So he is someone who knows the Indian business community and understands business. So I state before you today that the ICC court is committed to India. We are committed to working hand in glove with the Indian business community, the Indian arbitration community, and the legal community to strengthen arbitration infrastructure in India, promote arbitration in India, and promote Indian arbitrators. The ICC is the global voice of business, and the founders of ICC 100 years ago understood that to facilitate cross-border business, there needed to be a dispute resolution procedure that met the needs of global business. That purpose is no more true than today, and I am focused on assuring that our dispute resolution procedures meet the needs of today's global business. My focus is assuring that every aspect of international arbitration has a client mindset. So of course, outside counsel representing a party in an arbitration have a client, but for the arbitral institutions and the arbitrators, the parties in an arbitration must be thought of for purposes of this mindset as clients too. We have to be focused on ensuring that the parties, essentially our clients, are the ones driving the service requirements. Richard Susskind, the prolific author and a member of ICC's governing body for dispute resolution services, has explained that when people visit a neurosurgeon, it's not because they want surgery. What they want is health. And likewise, when parties are in a dispute, they don't hire a lawyer because they want an arbitration. They have a dispute and they want a resolution. When parties find themselves in the midst of an arbitration, they are really seeking a way to resolve that dispute, a process that allows them to identify opportunities to get to a resolution. I served as outside counsel for more than 25 years, and it was imperative to always ask my client at the very beginning of the matter and throughout the process about their objectives, or design our strategy or shift our strategy to meet those objectives. So from my perspective, the best way to identify what parties want in each particular case and improve our ability to respond to those desires is to engage the parties themselves more deeply in the arbitral process. With this approach, the parties can have more control over the way in which the resolution of their dispute unfolds. Given the expanding role of in-house counsel over the last decade to more of a business strategist and risk manager, we have the opportunity to ensure that the arbitration process better reflects this role. We know that today, general counsel serve as primarily counselor to the CEO and board of directors. They play a vital role in devising and implementing major strategies and operational objectives to create value and create competitive advantage. And because of the complex regulatory environment, especially in the life sciences sector, business teams can no longer develop strategy and then bring the deal to the lawyers to document. In-house counsel are instead now relied upon to assess risk Every day, they have to exercise their judgment as to what is worth the time and costs, and they are the ones responsible for the outcome. So if we bring them into the process, having them play a more central role, they can make the types of calls in real time, and they can have more control over and input into the way the dispute arises. Something as simple as asking whether in-house counsel, and not just outside counsel, want to be copied on all communications from the arbitral institutions and the arbitrators not only invites them in, but has the added impact of making arbitral institutions and arbitrators more aware of the clarity and structure of their own communications. Second, we want to encourage in-house counsel to participate in the case management conference or preliminary hearing. And I know from recent experience when I was chairing a tribunal that having in-house counsel present at that hearing enabled us to resolve a dispute about the timing of the hearing, the evidentiary hearing, right away. We were having a virtual session over a video conference, and I just asked everyone to go on mute and outside counsel to speak to their clients and get the issue resolved in 5 minutes. And that was so much more efficient than having multiple series of follow-up communications. Third, we don't want to think about the procedural timetable in an arbitration as written in stone. Instead, if the arbitration process has flexibility for adjustment without unnecessary postponement and delay, there may be situations in which the hearing can be shortened and certain matters can be resolved more efficiently on the papers, or time frames can be built in so that the parties can potentially engage in negotiation or mediation and reach a resolution. And last, I have a focus on transparency and predictability and diversity, because ensuring that the parties know what to expect from the process and ensuring that the international arbitration community reflects the global business community, we better reflect the interest of business. It is indeed my hope that the ICC is viewed as the partner you trust when a dispute arises, because business issues are in our DNA. And our objective is to help business get back to business. So I hope you reach out to me at any time, and I look forward to working with you and meeting with you as soon as possible in person.
Thank you. Thank you very much, Claudia, for your keynote. In fact, we really do look forward to receiving you in India sometime very soon. Thank you.
Thank you. Thank you.
Now, the next session is the panel discussion that we have for today, and I would like to hand over to our moderator for the session, Mr. Murli Neelakantan. Murli Neelakantan is a principal lawyer with Amicus, and he is also next general counsel. He used to be with CIPLA and Glenmark. Murli, over to you.
Thank you, Imran. So I think the plan for the discussion would be that we have no speeches. So I'm hoping that the participants will help us with some questions as we go along, but I will kick this off by looking at 3 key ideas and asking for comments from the panel. The first idea is fundamental to the topic, which is, do we observe an increasing preference for arbitration as a dispute resolution mechanism amongst companies in the life sciences sector? Now, why do I ask this question? I do because we don't hear of many of them, and therefore I think the number of lawyers and in the audience will be wondering if it is true. Does it really exist? Are there arbitrations? What kind of them exist? What kind of disputes exist? What is the lay of the land for arbitration in India? So to begin with, I'd invite Justice Kumar to please tell us what his experience has been and where he sees arbitration in the life sciences sector. Justice Kumar.
Thank you. Distinguished panelist, Madam Claudia, Dr. MURTAZA, and the distinguished audience to this webinar. Well, today we are concerned primarily with the cross-border life sciences dispute resolution through arbitration mechanism. Need to just see the word, what does exactly the life sciences would mean? Sciences that deals with living organism, their life process, their interrelation with biology, medicine, and ecology. The life sciences is a wider expression and take in its ambit the biological law as well as the pharmaceuticals. The life sciences interrelationship with other journal and specific laws across the globe relating to intellectual property law, administrative law, competition law, antitrust laws, and importantly, commercial laws is a complex field, and resolution of global disputes through international arbitration appears to be the way ahead. The life sciences have truly become global, and invocation of international arbitration mechanism is being preferred as an expeditious and effective dispute resolution forum. Just to look at the statistics that have been furnished, whether we talk of WIPO, or we talk of London Court of International Arbitration, or we talk of this American Arbitration Association, between 2009 to 2013, there has been a tremendous increase in arbitration cases relating to life sciences. It's right, 15% component is of that field, and the increase is practically the double. So that indicates to us that how much trust people have in the institutional arbitration today for resolution of their disputes. Now, if we take of COVID-19, as mentioned by my eminent predecessor speakers, is that COVID itself resulted in breach of contract, non-performance of contract, particularly in the field of pharmaceuticals. And it has given rise to so much of dispute resolution, which we need to look at. So the institutional trust, institutional integrity, which I think, and I can say with some confidence, the SEC stands for. So there would be a great belief in people to find alternative resolution system by invoking arbitration. The exact advantages thereof, I think we will discuss in the later part of the second session.
Thank you very much, Justice Kumar, for your comments. Could I ask JP if he'd like to make a comment on what's happening in the rest of the world before we get to India? It would be nice to understand what's happening with life sciences arbitration around the world.
Yes, thank you. And thank you at the outset to ICC India, to Imran Khan, to JSA for hosting as well, and to Claudia for your very prescient remarks, which are very welcomed. My experience has been that life sciences arbitrations, as Justice Kumar mentioned, are increasing exponentially, which is a function in my experience of two different factors that are driving this. The first is industry consolidation, which has occurred at a very, very rapid pace over the last decade. And secondly, much greater collaboration amongst companies from different jurisdictions, life sciences companies, primarily because of changes in the way in which commercialization and development have occurred. So the days of companies taking products in-house from the developmental stage all the way through the commercialization stage, as you used to see in the 90s and prior to that, have largely changed because of the economics of it. And now you are seeing many more smaller companies in jurisdictions outside of traditional life sciences strong hubs like Europe and the US, developing molecules that will then be licensed to a much larger company for later stage development. So that is something that I am seeing driving a lot of this. So as was mentioned earlier, You are seeing increasing number of licensing agreements. You are seeing a lot of IP agreements. You are seeing all manner of collaborations, partnerships, particularly in things like areas that were not really traditionally thought of as life sciences strong hubs, but things like manufacturing, things like distribution. So that is driving a lot of this increase. And what I have seen outside of India is almost a seismic shift in attitude towards favoring international arbitration as a dispute resolution mechanism, whereas previously it was somewhat disfavored for a host of historical reasons. So that is what I have seen, and I think it is a trend that will only continue. And as Justice Kumar mentioned, the COVID pandemic has really highlighted why international arbitration is so well suited for this area. There are a number of factors that we will talk about, but things like arbitrator expertise, procedural flexibility, as Claudia mentioned, confidentiality, targeted disclosure, all these things lend themselves well to international arbitration in the life sciences space in any event. But as COVID pointed out, those things become increasingly important in an era where you can't run to a court very easily to get very quick relief, where you can't easily convene people in the same room to do things when that is the expectation for most national courts. So the trend that I am seeing is reflective of the statistics that Justice Kumar mentioned, and I think those numbers will only go up. The one thing that I like to point out before I conclude my remarks is, if you look, there's an article I wrote that's in the Dispute Resolution Journal that discusses some of these statistics. If you look at the caseloads, as Justice Kumar pointed out, they are increasing at most arbitral institutions at a very, very rapid pace. It's double-digit growth. But the absolute number of arbitrations remains low relative to the size of the industry and the global economy. So while it is a multi-billion-dollar industry globally, and while it is one that is one of the largest sectors of the global GDP, it still only represents about 1% to 2% of most arbitral institution caseloads. And what that tells me is that there is significant room for continued growth, and that there is a huge opportunity there for people that are interested in the space, that have true expertise in the space, and that want to see the space benefit from international arbitration and from things like the ICC rules and ICC procedures. So that has been my experience globally.
Thanks, JP. If I could turn to Amar Gupta, I think one of the issues that a lot of lawyers will have is thinking about the judgments of the Indian courts, which seem to suggest that there is a bar against arbitration in IP matters. Is that a myth? Is it true? Amar, could you help us understand this better?
Thank you, Murli. Good morning and good evening, ladies and gentlemen. Thank you, ICC, for this opportunity. And it's an honor and a privilege to be here amongst you this evening. It is clearly a misunderstanding that there is a bar against arbitrability of IP disputes per se. The rulings are a little nuanced in that respect. Broadly, there are three categories of disputes where the question of arbitrability arises. The first category is dispute matters concerning the sovereign functions of the state, such as taxation, etc. Those matters, disputes involving sovereign functions of the state, are not arbitrable uniformly across jurisdiction all over the world. The second category is of the matters which the relevant laws have reserved for the designated courts to adjudicate upon. For example, the matrimonial dispute and rent dispute in protected tenancy. So these are the disputes which are not arbitrable because of the bar contained in the relevant statute. The third category, which is a little complex category, is the category which involves what is called the right in rem. The subject matter or the cause of action concerning right in rem, right against the whole world. Grant of patent and registration of trademark creates monopoly of sorts to the grantee, the person who has the grant in his favor, either the patent or registration. In that sense, it is exercise of sovereign function, granting a monopoly in favor of one person in respect of that patent or that mark, and it creates a right against the whole world. So what the Indian courts have held, that the grant of the patent and the registration of trademark, their validity, scope, effect, etc., will not be arbitrary. However, the Indian courts are consistent in their ruling that the subordinate rights arising from these rights, which are rights in rem, originating from the grant of patent or registration of trademark, will be arbitrable. Those will be usually contractual rights arising under the license agreement, license to use the patent, license to use the trademark, and the various dimensions and aspects of those contractual rights and obligations. Those can be freely and readily arbitrated upon without any impediment from the rulings of the Indian courts.
Thank you so much, Amar, for clarifying this. I think it was a big hurdle for many people who haven't read the decisions as closely as you have. Could I then move to Dr. Vivek Mittal and ask him, now that we have clarity on what can be arbitrated, what has the Indian experience been with life sciences arbitrations? Vivek?
Yeah, thanks, Murli. Thanks, ICC, for having me here. It's a great privilege and honor to be here. I would like to take your memory back to about 25 years back when litigation strategies were revolved around how long the case will take in courts versus, strategies right now in arbitration where people actually talk about facts rather than delay in the court process. So I think India is rapidly catching up, I must say. I think arbitration outside India is way evolved than it is in India. And I think it's evolving. Our thought process is also evolving in India, I must say. I can tell you that last about 15 years of my experience, I have seen a shift from people actually providing courts in India versus arbitration in India. That thought process is, as I said, is compulsorily changing. However, I must also want to tell you that there is an inclination towards arbitration, but this is not mandatory in in-house counsel's mind. And why I say this is because of multiple factors. I think people are still finding their faith in institutional arbitration. Of course, ICC is very reputed, and of course we would want to go to ICC, but especially Indian institutional arbitration is not that developed as of now. So there is a shift between two kinds of agreement. One is purely Indian agreements and one is purely international agreements. So whenever we do international agreements, we choose arbitration because of two reasons. One is we know that arbitration will be much better for us, and also pressure from other side, because other party, they are much more evolved and they think that arbitration would be better. Versus in India, I have seen a shift when Arbitration and Conciliation Act came in. We started providing for arbitration, and then we realized that arbitration is no longer working in India, and we jumped to the courts now. After 2015, Commercial Courts Act, we are now always thinking that whether for this particular matter we should go to court or we should provide for arbitration, depending upon complexity, confidentiality, intricacies of the issues involved, and kind of matter it is. So there's no straightforward answer that for each agreement we would provide for arbitration. Normally it's on case-to-case basis. That's how I am seeing the trend, at least in India. And I can say that being life sciences or pharmaceutical sector in India is more global. In global agreements, we are more and more seeing arbitration, that to institutional arbitration, not ad hoc arbitration. But however, the situation is completely changed in India, and I've talked to many colleagues of mine, many peers of mine. They are saying that no, we don't want to do arbitration in India because of various reasons. One of the reasons that is that the people arbitrating, the people helping arbitrate, and the people deciding are same. They are in court process, and hence the mindset to prolong the matter remains the same. So I think that needs to change, and that will change with more and more institutional arbitration in India. I was talking to my team actually some days back, and I was trying to understand for which cities I must say we provide for arbitration. I think the situation is, let's say my company is located out of Hyderabad. In Hyderabad, we don't have very evolved or maybe not that evolved institutional arbitration at all. So we actually think that where will be the seat of arbitration. And if the seat of arbitration other side is proposing in Mumbai, we also see cost involved. And then we see no, let's actually go to court rather than going to arbitration. So I think that also needs to change for changing this landscape in India. So those are my initial comments. Thank you.
Thanks, Vivek. I think this helps answer some of the questions for that General Counsel have on whether they should move to arbitration or not. I think I'll use this and cue from what JP said, which is that the pharmaceutical industry and the life sciences industry is getting to a state similar to where software was, which is that we don't see permanent enemies anymore. We don't see the line drawn very clearly versus between innovators and generics. It's all very fluid now. A lot of generic companies, especially Indian generic companies, will provide R&D services to innovators. They will produce API for innovators. So in a sense, the timing is right for us to look at arbitration rather than litigation. And as Vivek mentioned, we're seeing a lot more of it in the international space where there are no permanent enemies. You might be competing on a product, you might be fighting P4 litigation, but you're also supplying API to them, you're helping them with some development. And therefore, we're seeing more in the international space. I'd like to ask Justice Kumar if he thinks that there are still advantages, despite what Vivek says, for arbitration in India in the life sciences space, and what it might take to get it kickstarted. Justice Kumar.
Thank you. As I just mentioned, as everybody is saying, of course, it's a great pleasure and a privilege to be part of the ICC conference this time. What I am trying to say is, besides normally quoted advantages of an arbitration, that is the privacy, the confidentiality, ability to choose expert adjudicator, flexibility of process, importance where there is a greater ease for enforcement of awards, then comparative court judgment, cost effective and expeditious. I find very relevant factor is the parties have a greater control over arbitration process as well as the adjudicator who are going to act as the deciding factors. So that confidence between the people today is growing. I had a very pleasant experience where I was hearing a huge case on the original jurisdiction of Delhi High Court. And at that time, the parties during the injunction application arguments got into the mindset that they should refer it to arbitration. And that was totally not court-imposed arbitration. It was not out of an arbitration clause between the parties. What I want to emphasize is that people got confidence and they opted themselves that before a court you say we mutually would like to go to arbitration and have the matter disputed. So, and these 7-8 ingredients to my mind definitely cause a definite tilt in favor of arbitration, whether we talk at domestic level or we talk at the international level. But the international level, it becomes even more convenient, because otherwise you have chances of multiplicity of litigation, you have a conflicting judgment coming from different jurisdiction, you can avoid that. three court systems different, where tripartite agreements are entered. The residents are of 3 other countries, come into and people have the right to choose the arbitration seat. So it's a complete convenience of the parties. And people, with the passage of time, have realized, I don't say that arbitration is a substitute for court system, certainly not. But arbitration is a system where people voluntarily feel that their adjudication process can be better performed through a private system rather than through the judicial system. And we come to the comparative interaction which you observed that day. We will have something very nice to say on that. Thank you for that, please.
Thank you, Justice Kumar. I think this plays very nicely into something I had in mind for AMAR. We talk a lot about party autonomy playing out in arbitration, but in the life sciences sector, is there real autonomy? Are we still picking the same institutions, the same arbitrators, the same retired judges, all of whom are generalists? What do we really want in terms of choice of arbitrator, qualification, or seat? Amar, could you help us understand this a little better?
Sure. Murli, if I may take this opportunity to comment on Vivek's concern regarding the health of arbitration in India. Vivek, let me assure you that arbitration in India, in every sector, is thriving and is doing well, and you will be well advised to seat your arbitrations here. There are these international institutions all have the ability, and they do quite often administer arbitrations in any part of India. So that should not be a limitation or a disincentive that Hyderabad may not have an institution, but you can choose any institution and seek the arbitration anywhere. That is the beauty of arbitration. That's the advantage arbitration offers. As regards the choice of arbitrator, you don't have to choose the same people who decided the disputes elsewhere in other forum. That is again the advantage of arbitration that JP mentioned, the autonomy of the party to choose the arbitrator who they believe or they hope will be qualified and will have the necessary expertise for the dispute at hand. For the disputes in this particular sector, what is the unique requirement of the disputes in this sector? As previous speakers have said, that the disputes in this sector will almost always involve complex technical issues, a lot of science, and maybe a lot of commercial issues as well. So you need an arbitrator, an adjudicator who has the experience and understanding of the industry, the business, the practices, etc. Parties have the ability to make that choice through the provision in the arbitration clause itself, or even later on when the tribunal is being constituted. At the time of framing the arbitration agreement, parties are free to stipulate qualification for the arbitrator. While the freedom is there, I would caution against over specifying the qualification such that it becomes impossible to find a suitable match. It becomes more difficult than a marriage. And that may delay the arbitration process. The constitution of tribunal may also be delayed. The other aspect of party autonomy, which comes quite handy in case of disputes in this sector, Murli, is in relation to the seat, the choice of seat. The parties have choice of seat, ability to choose to seat the arbitration anywhere in India and anywhere in the world. So one can choose a jurisdiction which the parties believe that it's most suited for the peculiar nature of disputes in the life sciences sector. Once again, as regards that choice, which will be the best jurisdiction to seek the arbitration for these disputes? Generally, the general criteria for choice of seat or arbitration are there should the jurisdiction, the courts in the jurisdiction should be supportive of arbitration. They rather than disruptive or willing to intervene at every opportunity. One should be looking at jurisdiction which has speedy challenge procedure. Switzerland is at one end of the spectrum where there is only one instance challenge procedure available before the Federal Supreme Court. India perhaps would be at the other end where we have the possibly three rounds of challenge procedure depending on the outcome. So parties are free to choose within that spectrum, whichever works best for their dispute. The one more aspect that parties must be mindful of while choosing the jurisdiction for the dispute in this sector is the potential of IP-related dispute arising and the approach of the national court with regard to the arbitrability of those disputes. It is very important, as the speakers have previously mentioned, that quite often the disputes in this sector will be intertwined with the intellectual property dispute issues. They will not be purely commercial contractual issues. They will almost always be connected with some kind of intellectual property, right to use a patent, unauthorized use of patent, etc. It can take various shapes and forms. So it becomes very important that the seat of arbitration, at the seat of arbitration, the courts are more liberal. The jurisprudence, the legal framework is more liberal and permissive and leans in favor of arbitrability of those disputes. As I have clarified in my previous submission, that in India, the court decisions are quite clear. Inter-party disputes concerning grant of patent, registration of trademark, arising under a contract are without doubt arbitrable and can be referred to arbitration.
Thanks so much for that, Amar. I'd invite JP to make his comment on that. I suspect you may have a slightly different viewpoint from Amar on that, and would like to hear you on why is it that choice of seat really matters when there really has been a convergence of arbitral rules around the world. The arbitrators look and feel the same. Are they really very different? What really is the difference? Does it matter?
Yes, I do. I think that's a very, very good question. And I think, at the outset, one of the things that's of great interest to me is the recent Indian Supreme Court decision allowing 2 Indian parties to select a seat outside of India, which I think is a very interesting development. Choice of seat is obviously critical from the perspective of the New York Convention. So for the benefit of everyone on the call, I'm sure knows about this, but that's a very successful multilateral treaty that now has 170 signatories globally. It is accelerating in acceptance markedly. When I first started practicing about 20 years ago, there were only 120 approximately signatories. And there was a real risk that you could seat an arbitration in a country that had not acceded to the convention. The reality is, even though there are 170 signatories, it is not enforced the same way everywhere. And the single biggest problem that you have, and one of the past criticisms that India has suffered, I think a bit unfairly, is judicial intervention in arbitration, as someone mentioned earlier. So choosing a seat where you will have a supportive judiciary, as Amar mentioned, where you will have supportive international or even national arbitration laws, is very, very important. And oftentimes when I'm dealing with seat selection, I'm explaining to general counsel that some of the misperceptions that they have about seat selection are not concerns they should hold. So a few of the misperceptions about seat selection are that, one, it drives the governing law. It does not. You can choose a seat that's completely divorced from the governing law. It does not determine where hearings must be held. So as you correctly mentioned, Murali, most arbitral rules have converged, and there seems to be a race to do that. Virtually every set of major international and national arbitral rules allows you to hold a hearing any place in the world where you think it would be convenient, including virtually. And lastly, it does not determine where arbitrators must be from. So I sit as an arbitrator in life sciences disputes relatively frequently. Very few of those are based in New York, where I am based, and very few are even in the U.S. where I'm qualified. I guess in addition to England and Wales, but those things allow you a great deal of flexibility. So seat selection to me remains very, very important, and I think as Vivek mentioned earlier, the choices that general counsel run through sometimes are an interesting sort of checklist, but I think sometimes that checklist might be better served by thinking, okay, is there an arbitral institution in Hyderabad? There's not a major one, but that doesn't necessarily matter. So, you may well decide that the appropriate seat for my arbitration, the arbitration could be based entirely in India. Perhaps the correct seat is Mumbai. Perhaps it's not. Perhaps the correct seat is Singapore. Maybe not. Perhaps the correct seat is the US. And what I would be thinking of in that process is not necessarily where do I want to hold the arbitration from a physical perspective, because particularly in this day and age, that's not a very relevant consideration. I would be thinking, where will I need to enforce the award? Where will I need to seek judicial interim relief if that becomes necessary? Where will any interim award that might be issued by the tribunal be enforceable in the first instance or subject to vacature or set aside less easily or more easily? So all those types of things. I think the one real advantage that arbitration offers that oftentimes gets overlooked is that ability to do things anywhere where it's convenient and the ability to enforce globally. And I just want to add one quick point on that, because in the life sciences space, as AMAR correctly pointed out, there are oftentimes issues about things like IP usage, trade secrets, things which require not only confidential treatment, which is one of the great advantages of arbitration, but very quick interim relief. And in those types of situations, you benefit greatly from having an interim award that's issued by a tribunal that can be enforced in many, many jurisdictions around the world, rather than, say, a national court judgment, which will only have effect within the borders of that national court, save for any ability to enforce it outside of that national court, which is very, very difficult. So seat selection in that regard is critical. And just to add a very quick point on arbitrator selection, because I think it's worth saying, really one of the most interesting developments in this space is the development of a true arbitrator bar that has a lot of expertise within the industry. And that is one of the real advantages that arbitration can offer in this space over national courts. Having someone who truly understands the intricacies of the industry practice, and the commercial realities of the industry, rather than someone who may not have a lot of experience in that regard or a lot of commercial experience in that regard. And I'm always reminded of a very large ICC arbitration I did a few years ago that involved the commercialization and development of a product globally, where many of my clients' actions in the abstract looked very, very suspect. But the minute we got into the hearing and the arbitrators understood the commercial reasons why all those actions were taken, it became readily apparent that not only was my client not liable for having done anything, they were absolutely correct for everything they did. And we got complete relief in our favor. And had that been in front of a national court, I'm not confident that we would have achieved the same outcome. But because we had 3 arbitrators who understood the global realities of the pharmaceutical sector, we were able to achieve that. So I think it's a really critical thing to keep in mind when general counsel are considering, should we use arbitration or should we use court? Arbitrator expertise is a real differentiator, for most of these things. So it was a very long-winded way of saying, yes, the seat and arbitrators are important.
No, JP, I think that was very helpful. Also because of what we've seen in India perhaps hasn't caught up with what's happening with the rest of the world. We haven't seen the development of a pure arbitration bar here, or arbitrators focusing and specializing in particular areas. So I think what you're telling us is what's perhaps going to happen in the near future to us. So thank you for that. I'll just move on to something, JP, that you said about confidentiality and the way the life sciences arbitrations progress, why we pick arbitrations for the life sciences sector. Vivek, your thoughts on, does it really matter in the Indian context when whatever you do in the arbitration will still end up in court and everybody's going to know everything that happened in the arbitration?
As I said, Murli, I think we in-house counsels or general counsels, at least I choose, I don't think we go for arbitration in each matter. I think whenever we are drafting an agreement, arbitration or choice of law or dispute resolution clause is not a last hour clause. What we end up doing is we try and understand whether this is a commercial contract or based on IP specifically. And whenever it's a pure commercial contract, let's say exploitation of a license or in licensing or out licensing of a product, we may not need that many technicalities, right? But when it is co-development of any any specific product of ours or NCE of ours, then we might think of arbitration more. So it depends upon case-to-case basis. As I said, normally the yardstick is for international arbitration. For international contracts, we end up going into arbitration. For domestic, we generally, at least we don't generally provide arbitration that much. We do provide, but in certain cases. However, it also depends upon kinds of matter it is, kind of case, kind of agreement it is. If it is co-development, then yes. Of course, I agree with JP that arbitrators' qualification makes a lot of difference. But unfortunately, in India, we don't have too many arbitrators having this technical knowledge. In fact, I was approached by one of the law firms in my previous life that can you be an arbitrator, because there is a complex arbitration matter between two pharmaceutical companies. They are not able to find an arbitrator who also has legal knowledge as well as technical knowledge. I think that mindset needs to change. I think what we can do with institutional arbitration is that we can have subject matter experts where institution will tell them that how to take the process forward, but they provide their input on their expertise rather than purely on legal basis. However, in India, if you see, mindset still is that a arbitrator needs to have a legal background as well. So those are my comments, Modi.
Thanks, Vivek. That's, I think, the experience of many of us who've been general counsel and Indian arbitrations. We tend to see, irrespective of what the subject matter is, the same law firms, the same lawyers in court, in arbitrations, as judges, as arbitrators. So it does get to be quite tedious in some ways to get serious expertise, both in the bar and the bench. So I think you have the sympathies of many of your colleagues from the life sciences sector, at least, and likewise from the software and technology sectors. They have the same issues. And perhaps it's something for institutions to think about. Can they get more specialists on their arbitral panels than the same lot that keeps churning up in every one of the arbitral panels? It's one, I think, for the ICC to take away from this one. I'll come to Amar next and ask him, does the choice of arbitral institution really matter? I mean, you did mention that the seat matters, but does the institution matter? What are the big differences? My own view, and I think view of many, and what's being mentioned in court as well in the Amazon Reliance matter, is that there's a convergence of rules. They all look the same. What's the big difference, Amar?
Well, you are right, Murli. As you have said, and previous speakers have said, there is convergence of rules. Almost all leading institutions achieve the same degree of excellence in the different aspects of arbitration, such as the privacy and confidentiality, robust rule of procedure, and the large pool of arbitrator. There is very little difference amongst the leading institutions. WIPO Center does stand out for intellectual property dispute. They are designed for that. You know, they do that mainly. as a mainstay of their work. And therefore, WIPO Center is, of course, takes a lead. Amongst the pure arbitration institutions, ICC, LCIA, SIAC, they come up to the mark on all the relevant aspects. However, in my experience, I have found that ICC does stand up. And I say so not because they support this webinar. I speak from experience. They have this unique procedure of appointment through the National Committee. That gives access to a large pool of very qualified arbitrator. Parties are free to, there is a large pool available to select from in terms of qualification, in terms of expertise, in terms of nationality. Nationality is an issue as well in appointment. So in my experience, ICC stands out a shade better, but by and large, all the leading institutions are at par.
Thank you, Amar. I'd like to go back to Vivek. Vivek, what's the key challenges in the management of, let's say, cost, evidence, counsel, all of these things between litigation and arbitration? Do you see a big difference? Is it cheaper? Is it easier? What's the real world telling us, Vivek?
So one word on this, and that's pretty much prevalent amongst us. Arbitration is costly. I say with all candidness that arbitration is costly. That's how we in-house counsels think. Increasing trend in India is that if you go to same law firm who's doing a litigation versus you want to engage them for arbitration, they'll be notch higher for arbitration. I don't know why. I still could not understand why arbitration should be more expensive than a normal litigation. Why hourly rate? And I'm not saying larger law firms, but many law firms are also providing that they want to work on percentage basis for arbitration. I still don't understand why that's happening. I've heard that, but I'm just saying that, what are the trends, right? How people are reacting. In my view, whenever arbitration happens, whenever we get into arbitration, our thought process is that how costly the arbitration is. And what will be, whether it will be better to settle with parties directly or get into arbitration. I think one cost of arbitrators are pretty settled. I don't think when you're going to institutional arbitration that you have to worry about cost of arbitrators. I think it's cost of lawyers who are assisting for arbitration. That makes a lot of difference between arbitration, go for arbitration or go for settlement on your own. And that's one of the driving factors internally. For international arbitrations, I think when we agree for arbitration, we know that what all we are avoiding. I think we are avoiding multiplicity of disputes or cases in various countries, also not reaching to conclusion, and hence international arbitration provides a greater value versus domestic arbitration to us. And that's the thought process which is emerging. And hence the reason, again, I keep saying this, sorry for this repetition, that internationally, when there are two countries involved, arbitration makes much more sense versus domestically. I'm not saying, I'm not debating. I heard that, some people carried from my conversation that I am not proposing domestic arbitration. I'm not saying that. However, the percentage of we agreeing to international arbitration is much more versus domestic arbitration because of cost. I think that's one of the bigger factors for Indian companies. Other than that, I completely agree, confidentiality, privacy, faster resolution. And again, I think faster resolution is one of the things is debatable again in arbitration in India. In any event, but evidence preparation, let's say, bringing everyone together in 1 day or 2 days and trial gets over in one sense. That's very nice for arbitration. However, there are still some challenges around costs, which needs to be taken care of.
Thanks, Vivek. I think a lot of people sympathize with your viewpoint. It's been our experience as well. I think we all meet each other and speak often on this issue, and we're more or less agreed on some of these things. I think the only point I'd like to remind you of is that a leading senior advocate and advocates here would cost much more than a leading QC in the UK. And so even if they don't turn up, you end up paying a lot more here. So that, I think, risk in litigation is taken away. I find that leading counsel behave much better in an arbitration than they behave in court. So I don't know how they manage to change their behavior from one day to another, but all the things that we watch in court just doesn't happen in arbitration. There's less drama, things get done. They're very sensible about what they say. They're limiting themselves to the facts and the issues that they're debating. So I can see why it is that some of us prefer litigation in India, but it's no competition when it comes to international arbitration, where everything seems to work to plan. We pay the fees that we expect to pay. There are no surprises, and things get done as we expect them to be. The last part of this really is we've gone through, why we want to do arbitrations, the cost of arbitrations, all of these things. JP, what are the challenges in enforcement? If you can tell us what happens in the rest of the world, I think Amar will have some stories on what happens in India.
Sure, happy to. And just to quickly pick up 2 points there, I think one of the things that that I would emphasize, because I think it's relevant to enforcement as well, is the institution does matter. And one of the great advantages that ICC offers is court scrutiny. And as everyone on this presentation will appreciate, a final award and an interim award at the ICC will have gone through a process of review whereby very experienced practitioners are looking at it to ensure it makes sense. They are not looking at the merits of it. They are not looking to overrule the arbitrators in any way, but they are looking to make sure that the award is enforceable. And that is a real advantage I have found when dealing with awards globally, particularly in some jurisdictions in which they may not be as familiar with international arbitration. Just quickly on costs as well, because I think that is also relevant to enforcement. The costs of an arbitration are certainly higher in court in the first instance in many cases. And part of the reason is you are paying for the infrastructure that a court otherwise provides. But one thing I always like to remind both counsel and clients about is the cost ultimately of getting through an arbitration can be much lower if it takes less time, takes less discovery, and is more focused than it might otherwise be in court. So while I'm not an Indian practitioner by any stretch, and while I'm certainly not purporting to be qualified in India, I've done many arbitrations over the last 20 years involving Indian parties. My first one as a first-year associate in Bhubaneswar for many years. I can tell you, I would say, or I would suggest that the time value of money certainly argues in favor of arbitration in many instances. Not all by any stretch, but many. And that is certainly a discussion we have with domestic arbitration in the US as well. Now, in terms of enforcement globally, I think one thing that has been a true positive trend globally is, along with the increased acceptance of the New York Convention that we talked about earlier, you are seeing a clear trend towards accepting arbitral awards as enforceable in the first instance, subject to very, very limited defenses that can be found in Article 5 that are becoming increasingly more difficult to prove. And that is a very positive development. It's certainly one you have seen in India markedly over the last few years. My last international trip in 2020, early 2020, was to speak at a FICCI conference in Delhi. And we were talking quite a bit about all the pro-arbitration decisions that had come out of the Indian Supreme Court. That trend is very, very strong in India, but you are seeing it elsewhere too. So I used to live and practice in Dubai. The UAE was considered a jurisdiction in which enforcement was very, very challenging. That is I sit as a member of the Saudi Commercial Center. Enforcement for that center is paramount. And Saudi Arabia is traditionally viewed as a jurisdiction in which enforcement was, if not incredibly challenging, almost impossible. That is no longer the case by any stretch. You are seeing that same trend in Latin America, where awards are being enforced with increasing regularity. And another jurisdiction that I think had traditionally a very poor reputation for award enforcement was China. I don't think that reputation was deserved, but I think you are seeing much more improved enforcement there as well. The thing that I think is most interesting to me now is the track record that is developing around the world with the enforcement of emergency and interim awards. And this is of particular relevance to this industry because it is, as we discussed earlier, something that is a key feature of a life sciences arbitration, particularly cross-border. You know, as we said, if you have an IP issue, if you have a trade secret issue, as often occurs in this space, and you get an interim or an emergency award, you want to be able to take that award to all of the New York Convention jurisdictions that are relevant to your dispute and enforce concurrently, rather than having to start, you know, say 15 different litigations in 15 different courts that will move at different speeds, as I believe AMAR said earlier, could reach conflicting outcomes, and most importantly, will decide the disputes under their own procedures and their own national laws oftentimes. So you have this incredible matrix of difficulty if you try and do that. Enforcement of interim and emergency awards around the globe remains a bit spotty. Jurisdictions like the US will treat an interim award as final on the issues it decides and will readily enforce that award under the New York Convention. There are some very noteworthy jurisdictions that take a very different approach. And one seat in particular that I will not call out by name, but which is very, very popular globally and amongst Indian parties in Europe is very, very challenging and very, very difficult about enforcing interim awards. That's very problematic. Singapore has become a jurisdiction that has become very, very willing to enforce interim awards. That's very, very relevant to Indian parties. And certainly India has become a jurisdiction in which enforcing interim awards is possible, and particularly interim relief in aid of arbitration. Now, I won't purport to be the person that can walk through all the hoops of how you do that. Having done it relatively recently, I can tell you it is a very interesting workaround and a very creative solution that achieves the exact outcome that you would hope for. But you know, I look back at some of the old Indian Supreme Court decisions that got heavily criticized, particularly some of the Section 9 decisions. And when you look at those, many of those were actually designed as a way to afford interim relief, where the solution may not have been ideal, but it was well intended. A lot of those things are changing now around the world. But you know, to sort of summarize, I would say global enforcement is becoming increasingly strong as a general global trend. There are obviously some holdout jurisdictions that are problematic. That will always be the case. You know, even what are deemed to be, you know, I'm air quoting here, more developed or experienced jurisdictions have their own enforcement challenges. You know, the US will come out with enforcement decisions on a monthly basis that will make you scratch your head and wonder, how was that conclusion possibly reached? You've seen things like that in the UK as well. I mean, the Dalla decision was very, very heavily criticized. But as a global matter, I would say enforcement is improving incredibly, and I would only see it improving globally, and particularly in India, where the Supreme Court is so focused on being pro-arbitration and pro-enforcement.
Amar, I'm sure you'll have something to say on this, especially with what's playing out in the courts at the moment. I won't ask you to comment on the case itself, but it raises some interesting issues on emergency arbitration and interim awards, emergency awards. A quick word on that?
Sure. See, difficulty with India is that the signals, that the cues that our Supreme Court is sending out, it does not somehow gets transmitted to the lower courts as fully and effectively as they should. Therefore, the experience in India can be diverse. It depends on which court you are in for the outcome, for the kind of the quality of outcome. I have no hesitation in saying that Delhi High Court is very positive and very supportive of enforcement proceeding. It brooks no nonsense, and the limited grounds that are available are swiftly gone through, and those objections are dealt with, and the enforcement is proceeded with. Even in very, very hotly contested matters, the example that you are referring to, the pending matter that you are referring to, Delhi High Court remarkably did its job, okay, and in a remarkably short time. But the same kind of speed or efficiency or enlightenment in understanding the jurisprudence and the limitation of jurisdiction and enforcement proceeding, it cannot be guaranteed in all courts. In several other courts, particularly in states where the High Court does not have the commercial division, and you end up in the district courts, the so-called the commercial court, where nothing has changed except the signboard outside, which says commercial court. Everything is the same. The proceedings can be extremely tardy, tiresome, and frustrating. So as everything else in this country, one answer is not possible. It depends which court, which state you are in, and answer will depend on that. But by and large, I think the trends are encouraging. And I hope that the signals, the decisions of the Supreme Court, the message that Supreme Court is sending does percolate down and then reaches the other courts of the land.
Justice Kumar, would you want to make a comment on this last aspect that Amar mentioned? We have the award, everything's gone well, we come to enforcement. Are the courts really supportive? Do they understand what has happened? Do they understand the life sciences sector and arbitrations there? What do we need to do about it?
No, I can first take 1 minute, because I find that the two doubts in the mind of the distinguished members present are very, very prominent. One is the costing factor. Other is that probably there are no specialized arbitral tribunals or the arbitrators to adjudicate upon Indian disputes, particularly in the domestic jurisdiction. With all the humility at my command and with 50 years of little experience as a lawyer and a judge, I would think that these are not correct impressions. Firstly, most of the institutional arbitration in India have fixed fee panel. I am an arbitrator in a case where there's 1,000 crore rupees claim, and the fee payable to the arbitrator is something like 21 lakhs. So I don't know how cheaper one would look for. But secondly, the expertise on the arbiter tribunal. See, it is your nomination. Most of the institution, I'm sure the ICCI would also be thinking very widely that what kind of an arbitrator is to adjudicate upon the disputes. Parties nominate. Parties have the freedom of nominating their own arbitrator. You pick. I have arbitrations where there are civil engineers, where there are technical people on the arbiter panel, and they are equally a judge. I will give you a very specific instance. That is the National Green Tribunal. That's the statute of the Parliament. We had expert members who were professors, scientists, researchers, forest people as judges with us on the panel. So it is not something unknown to the Indian system that you have specialized people as members of the arbiter tribunal to do the justice. So that is one aspect I would look at. And acceptability of an award in India, as which you just mentioning, is equally effective. Courts are developing the principle, as even Duffy said just now. The courts are walking on the path of least judicial interference in arbitration proceedings. But ultimately, it's a question of a mindset of people. As Claudia said in the morning, in the earlier part of the day, that counseling for the parties is very important, even in cases of arbitration. Now, see, mindset of people, I'll give you an example, which you will be surprised. Arbitration panel is constituted the tribunal. First application is under section 16 that you have no jurisdiction. Disputes are beyond the arbiter jurisdiction. You decide that application. So party goes to court. Court dismisses it. Then application under 17, interim order. Arbitrate tribunal grants it or declines it. You go to court. Okay. Third, if everything else fails, Then the party comes and says, now the arbitrators are biased, therefore they should be removed. Therefore, Section 2023 application for removal of the arbitrators. So what I primarily request is that we have to have education. Our mindset have to be to the acceptability of arbitration as a voluntary forum of adjudicator process. Just giving you the last thing that you have assigned to me is the real difference between the arbitration sector today and the normal court system prevailing across the globe. That is true. You know, most of the courts have one system or the other system, which is common. First distinction that I would like to draw is that the arbitration allows for resolution of multi-jurisdiction disputes in a single forum. Opposed to this is that you go with one issue before the court and it becomes a multi-dimensional litigation involving different cases. So therefore, the controversy gets enlarged before the courts normally, while in the arbitration, the controversy gets limited. Then you have the greater protection of trade secrets, other confidentiality information is possible in the arbitration proceedings, while in the court, it's a public document and public, open to public inspection. In our system, the court proceedings are open to public, unless and until the court specifically orders camera proceedings or some order of that kind. Then you have international arbitrations are less formal in comparative case in invoking the appellate jurisdiction, revisional jurisdiction, extraordinary jurisdiction of courts in the normal channel of administration of justice system of that court. Now, challengeable awards are on a very limited ground. Even Section 17 is interfered on a very limited ground. So does the final award under Section 34 of the Act is on a very limited ground, as Mr. Amar Gupta also mentioned. Better court time management.
We appear to have lost Justice Kumar momentarily.
Yes, shall we just wait for a...
You know, while we're waiting, just one quick point, and I will then stop talking when Justice Kumar comes back. But I wanted to re-emphasize his point about single venue proceedings. I think that is really one of the strongest advantages that that arbitration offers this space. And we talked about it a bit earlier in the context of interim relief. But one thing that oftentimes occurs in this space is you will have many different jurisdictions implicated. And as I mentioned earlier, trying to bring a dispute or get effective relief in all of those jurisdictions at once is incredibly challenging and is, to Vivek's earlier concern, very costly, incredibly costly, in fact, and costly from both a straight monetary perspective and very costly from a risk perspective. If you have to go out and have your IP challenged or challenge someone else's right to use your IP in many jurisdictions, the risk that you face is massive. And doing it through arbitration is a much safer bet in my view. But it looks like we've gotten Justice Kumar back, so I will cede the floor to him.
Sorry for interruption. The last thing I would like to say is that the traditional court system, this is the vital factor, that you have no interlocutory proceedings pending before an arbiter tribunal normally. Once the arbitration commences, it meets the end of passing an award. But before the court system, you have interlocutory proceedings, which are very prolongish, which are very appellate repeated jurisdictions. So there is a kind of a collateral issues become more prominent under the court system rather than before the arbiter tribunal. Before the arbiter tribunal, you have a more concentrated and more centralized viewpoints from both sides, which help in expeditious disposal. And acceptance of and enforcement of award is very valuable, especially in face of the New York Convention, where 170 countries, as DUFFY also pointed out, they have accepted it. So the international level, the acceptance and implementation, enforcement of award is much easier than a court decree. And that's all I would like to say. And thank everybody, please. It's a great privilege to be part of this ICCI program. Thank you so much.
Thank you, Justice Kumar. JP, final comments before we wrap up?
I will keep them very brief because everyone has been very patient, but I thank you everyone for taking the time to discuss this topic. It really is critical. And I think one of the things that that I don't want to lose sight of is we discussed a lot of economic statistics earlier and the importance of India's, the pharmaceutical sector and the life sciences sector to India's economy. What we did not mention was the very significant role that the tech sector also plays, which is closer to about 8 to 9% of Indian GDP. It's about 50% of the global GDP is contributed in that space by India. And the convergence between those two sectors is very, very significant. You know, I'm reminded of any number of instances in the last few months where I've seen clear instances of the tech sector and the life sciences sector coming together, and that will benefit India significantly. And as India continues to lead in that space, I hope that people keep this dispute resolution mechanism in mind for those types of contracts, because all of the advantages that we have discussed for pure life sciences disputes become even increasingly important when you are talking about a contract that involves med tech, that involves pure technology interfacing with life sciences, like a portal for tracking pharmaceutical usage or tracking patient results. All of those things will benefit even more from international arbitration than a pure life sciences contract will. So that would be my my suggestion and my admonition to everyone to please keep that in mind.
Thank you, everyone, especially my panelists. The floor is yours, Imran.
Thank you. Thank you very much. I think we are going to be closing in time. If anybody else wants to make a comment, we can still spare a minute or two. But I think thank you again, everybody. Claudia, panelist, and welcome, Tejas. Good to have you back, and everybody else. We will be in touch. Thank you. Thank you for joining us.
Thank you, everybody. Excellent program, really high level discussion. So really glad to be a part of it.
Thank you.
Thank you, everyone.
Thank you, everyone. Bye-bye. Have a good day.
You too.
Thanks.
And thank you, Tejas. Look forward to working with you.
Thank you so much.
Thank you.
Thank you, everyone.
Yes, thank you. I have a small question, JP. Can you?
Yes.
Yeah, it's a privilege and it's an honor to join in this meeting and to listen to all the luminaries who are present in this meeting. I have a quick question. See, when a contract's having a clause about arbitration, and as a jurisdiction also very specifically mentioned. Okay, so when a bank guarantee has been issued to a contractor to perform, to comply with certain terms and conditions of the contract, and if in case if that party is not obliging the conditions of the contract, and the jurisdiction is in somewhere else, so it takes a reasonable time to approach that court. So in the meanwhile, do we have any an opportunity to approach the local court to obtain stay on the invocation of the bank guarantee, since the bank guarantee is an independent contract wherein a bank is located in India, and the parties have chosen the arbitration in other territory. So do Indian courts have any jurisdiction to entertain this petition and to grant the stay on the bank guarantees?
You know, I think that sounds like a question that probably implicates Indian law more than international arbitration, and it's probably more banking sector related than life science related. So what I would suggest is perhaps you email us directly afterwards email the speakers and those that are in a position to chime in will. I would simply, I think your question highlights one interesting point though, which is two things I would just reiterate. Under the ICC rules, you are certainly, if you have an ICC arbitration clause, you are certainly free to approach national courts for interim relief if that has been provided for in the clause or not excluded by the clause. There's nothing inconsistent with those two things. And interim relief, again, in the life sciences space is very, very important. So it's another reason to select arbitration for a life sciences contract. But I think with regards to your specific question, I would suggest reaching out to the panelists directly, and someone who's qualified in India could probably answer that question better than I.
Yeah, I think we are completely out of time. Thanks so much, JP, for doing this. What I would suggest, you can send it to us, Shiva, and we'll direct your query to the, as JP mentioned, to a qualified person. We'll do that. Thank you. Thanks. And I think we should close on. Thank you. Thanks, everyone.